Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Our next case is Ward versus Halprin, and we'll hear from the appellant.
May it please the court, Chief Justice, Associate Justices, my name is Rebecca Wofford. Along with my co-counsel Hunt Wofford, we represent Justin Ward. At this time, I would like to reserve 5 minutes for rebuttal. Justin Ward is the biological father of 2 minor children. He had these children with his wife, Jessica Halprin, during their marriage. At the time of the initial custody determination, one of his children was starting kindergarten and the other was in preschool. After making substantially positive facts about both parents, the trial court granted joint legal custody to both parents, but then granted all final decision-making to mother and awarded her attorney's fees. With regard to the first issue, final decision-making to mother on all major issues for the children was not supported by the record, not supported by the court's findings of fact, and should be vacated. Our North Carolina General Statute 50-13.2 states that the trial court shall award custody of the child to such person, agency, organization, or institution as will best promote the interest and the welfare of the child. Although the term legal custody is not specifically mentioned in our statute, our North Carolina case law has defined legal custody as the right to make decisions with important and long-term implications for the child's best interest and welfare. This includes major decisions in categories such as the child's education, healthcare, religious training, and the like. The court, in its amended order, had a number of findings of fact that were positive for both parents that fall within these categories of the well-being of the children, the medical, education, and even the extracurriculars regarding the children. What the court found that was that mother and father both had a close, loving relationship with their minor children. That both of these parents promoted the minor children's relationship with extended family. As to medical, both parents were very attentive to the minor child Peyton's food allergies and his medical needs surrounding these allergies. As to education, the court found that both mother and father had good relationships with the minor child's teachers and school administrators. The minor children were excelling academically. When mother and father lived in Charlotte, North Carolina together as a family, they looked at schools jointly for the minor children. At some point, some problems arose, and the court found that the parties were not effectively co-parenting. The examples the court gave about co-parenting was that some unilateral decisions had been made by mother and father. Mother had made unilateral decisions about where the child should attend school. And actually, the court stated the credible evidence showed that mother did not inform father that although she knew and was aware that the father had enrolled the child at Dilworth Elementary, that she enrolled the child at a different school in Concord, North Carolina. A week went by and the child attended the wrong school. This was mother's unilateral decision-making and her lack of communication with father that caused this disruption. In fact, in the order, the court says this is the only area where there was a substantial impact on a child. In other areas, mother also made additional unilateral decision-making, including having the children attend camp in the summer during dad's custodial week, deciding that without dad's involvement. Dad had made some unilateral decisions as well, but his involved transportation and exchange. There's nothing in the order that suggests that this actually had an impact on the children. Both parties were found to be fit and proper. and that they should have impact and input into the major decisions regarding the children. The court then concluded that the parties should have joint legal custody, joint decision-making, but awarded final decision-making in all areas to mother. This goes against the constitutional underpinnings of a parent's right to raise their children. It goes against our statute's desire to have the parents be involved in the best interests of the child be met. And it goes against the definition of what our courts have said is joint legal custody, joint custody. So our court has defined in Patterson versus Taylor in 2000 that joint custody should be defined as each parent having a degree of control over and a measure of responsibility for the child's best interest and welfare, because parents are treated equally under the law. Although this court in Ruetten versus Ruetten in 2020 made sure to clarify some misunderstanding about the presumption that exists in cases where there's a third party and a parent, there isn't a presumption between two parents. The parents are treated equal under the law, meaning that both parents have the right to the paramount right to custody and care and control of their children. That gives them a degree of control over and a measure of responsibility for long-term decisions that affect these children. Even though our trial courts have wide latitude to decide these issues, that latitude is not unbridled. The starting point should be pure legal custody. And only after that, if it's not in the best interest of the children, should the court deviate from that joint decision-making. For the
Counsel, well, when you have a situation where both parents are equally situated in terms of what has been found by a trial court, joint legal custody, they're equal in that regard. Also, find equal decision-making authority, they're equal in that regard. Where there's a hopeless impasse, what should a trial court do in terms of finding, colloquially speaking, the tiebreaker?
Yes, Your Honor. You raised a good point. I don't believe that our cases suggest that pure legal custody is the only method that the court can have in its disposal. If the court believes that it is important to split legal authority, meaning giving a tiebreaker some to each parent, then that would still give each parent some degree of control over the children and puts incentive in place for both parents to be included in the discussion. If, however, the court gives them shared legal custody, joint decision-making, then the parties are encouraged to either go to mediation, and in cases of high conflict, that the court appoint a parenting coordinator to help them with communication in the event that they can't decide, to help them make a decision that's in the best interest of their children. In essence, putting a neutral party in place to help when matters can't be resolved. There may be a time that a party would need to return to court if they're so adamant in their belief system about something important for the child. For example, a school choice issue. That is a case where you might find parents in deadlock with one another. One parent believes very strongly in a certain type of school and has good reasons for it. The other parent believes in a very different school, but also has equally good reasons for it. There's no tiebreaker between the parents. That may require a judge to intercede and help them navigate what would actually be in the best interest of the child.
What if there's a time crunch issue, understanding that certainly perhaps a third party might be helpful, such as a mediator or a trial judge? But let's take that example in this case where there was a camp decision that needed to be decided, and the mother decided to put one of the children in camp, albeit it fell during the father's week to have some visitation, where you don't have the luxury of having time. Again, going back to a tie-breaking situation, what's a trial court to put in place to honor both parents' recognized ability to contribute favorably to the child or children?
Your Honor, I understand your question, and I think it's an important one where time is of the essence in some decisions. And I think that in those types of cases, the court can either put in a time factor where the parties go to mediation within a certain amount of time and have access to the courts, or that maybe that is the reason why tiebreakers should be used. And different areas should be given to different parents where they show some fitness in that area to make a better decision. We have had cases, certainly this court has had cases where the trial court has said both parents have an equal voice, but I'm going to give tie-breaking decision authority in certain areas, some to each parent. They may give religion and medical to one parent, and they may give education and extracurricular to the other, which would eliminate the time is of the essence factor, meaning that parent can decide that camp is important and needs to make that decision after having communication with the other parent. The important part about that is that both parents have a measure of control. Not one parent has all decision-making power. There's not incentive to include another parent if you don't have to be included in their conversations when they make this, when the reverse isn't true, meaning both parents have incentive when they each have a measure of control over decision-making authority. So there are times when tie-breaking is warranted, and there's times when tie-breaking is warranted when a parent has acted in a way that is not in the best interest of the child. For example, in 1996 in McLaughlin versus Klein, the court carved out religion as an exception and allowed the father to make the decisions in the area of religion because there was some detrimental effect happening to the child. The parties had agreed to raise the child in the Jewish faith. Mother was introducing Christianity, and it wasn't just an introduction that meant that the child was exposed to two different religions. It had gotten to the point where it was actually affecting the mental health of the child. The court said, in this situation, because of the impact on the child, we believe father has the better handle on the religious aspect, and we're going to allow father final decision making in the area of religion. That didn't carve out all decision making and not allow mother to have any decision making at all. In other cases, the court have said there needs to be specific findings of fact in order to deviate from pure legal custody. In the Deal versus Deal case and Hall versus Hall case, both of those cases said the court didn't do enough in order to establish that there were findings of fact that would make it warranted to deviate from pure legal custody. Timing being of the essence, or if a child had certain medical needs, or if one party was the victim of domestic violence. These are all very specific fact circumstances where a court may say there's a reason to put a final decision maker in place. But when they do so, it has to be specific to certain areas and for very specific reasons. The findings of fact must support that there is a reason to deviate from pure legal custody because you're carving out an exception to joint legal custody.
Are you contending that the trial court erred or otherwise was inadequate in its determination that there would not be sufficient input by either parent when it came to having that amount of time within which to have telephone discussions as well as email correspondences exchanged? Was that erroneous by the trial court, inadequate from a recognition standpoint in light of the shared custody circumstance?
Justice Morgan, I believe it was inadequate under the circumstances. As the dissent in this case said, it doesn't solve the problem. There's no remedy in place with what the court put in place. If you look at that section of the order, the court tried to include father in decision making by only allowing an email exchange and one phone call. That is his participation. It's not true decision making. He has no authority whatsoever. All decision making, meaning mom can now make all unilateral decisions. All she has to do is send an email, wait 48 hours for a response email, and then have one phone call. And then she can make the decision that she wants to make in every area involving these children until they're 18 and beyond. So that is what it doesn't help remedy the situation, as the dissent pointed out. It doesn't give father any authority to make any decisions at all. And it goes back to the fitness of the parent. Who here did the better job of facilitating communication and who did not? In this situation, mother has shown in the past that she will make unilateral decisions and not include father. Father had absolutely no idea that the child was attending the wrong school for a week. And yet mother has final decision making for the children in all school issues. In another example, mother signed the child up for camp during summer during father's custodial week without including him in that conversation or allowing him any. It was a complete unilateral decision. So most of the cases where you see a carved out exception, it's against the parent who was not inclusive of the other parent. Here we have mother not inclusive of father in major issues involving the children, education and camps. And she is rewarded by being given final decision making in all areas. That is a punishment that father certainly didn't deserve, and it doesn't show that there's any accountability for mother to include father in any discussion, and it doesn't serve the best interests of the children. It would make more sense for there to be a direct causal link between the things that have happened in the past and who is being granted decision making if there is a split of authority. Yes, there have been disagreements. Yes, there were times when father made his own unilateral decision making, but his were an area of transportation and exchanges. And no point in the court's order does the court say that that had a detrimental effect on the children. In cases that have come before this court, Peters versus Pennington being one prime example, a parent was found to not be given final decision making because she had been the person causing the behavioral problems and causing problems for the children. She wasn't rewarded with giving final decision making. Here we have a parent who's actually rewarded. She didn't include father in two major areas of decision making, one being school and the one area where the trial court said, this is the one place where I can show there's a significant impact on the child. The child attended the wrong school for a week. I don't know if that will have a long-term effect on the child or not, and there's no information in the court order as to whether it would have a long-term impact on the child. But in the moment of him going to kindergarten for a week, it was mom who didn't communicate with father. It was mother who made the unilateral decision, and then the child was harmed by it. And no other place does it show that the child was harmed by the lack of communication or the unilateral decisions being made. So if there should be at least a causal connection between how we split the legal authority. If one parent has shown in the past that they are the better person to be inclusive of the other parent, or to promote the best interests of the child. In one of our cases, it talks specifically about this Altman versus Altman. The mother could rise above the animosity between the two parents and make good decisions on behalf of the children. In this instance, it doesn't appear that mother as a parent was rising above the animosity in making decisions, and yet she's rewarded with 100% decision making in all areas for these children. We would promote that this court follow that accountability and measure of control for both parents would equal in most circumstances that the parents should share joint decision making. And if not, that if we are going to have a split in the authority, that there is some measure of control given to both parents, that each parent have a right as a final decision maker, and that way both are held accountable. And it should be about the children and has there been any detrimental effect caused to these children, and would there be if father was given final decision making in some areas? There was simply no part of the order that spoke to whether anything father was doing was having as to decision making was having a detrimental effect on the children. Other cases, like Eddington versus Lamb, the court has said a father who fails to give ADHD medicine daily should not be able to give final decision making or have decision making authority where he's failed to give ADHD medicine daily. Now, that didn't take that father out of all medical decisions. That took that father out of specifically not being able to make a decision about ADHD medicine. Mom was given that authority because the causal connection to the detrimental effect on the child. Here, medical decisions, the court specifically states that both parents have done well with the child's allergies. We have a child with some medical issues. He has some allergies, and both parents have acted very responsibly in that area. And yet, father was not given any medical decision making or any medical decision making, final decision making over medical concerns. Rather than just even carving out an exception, the court took that away completely, even though there was nothing that showed a causal connection to a detrimental effect on either children in the area of medical. This is a father who the court has said has a loving relationship with his children, who is fit to be a parent, who is a loving, kind parent who has been involved in their lives, and yet he is not being given any opportunity other than a phone call and an email exchange to have impact on the long-term effects of his children's lives in major areas of decision.
So I can get an appreciation for your position. Let's say hypothetically that the trial court did give each parent certain areas of final decision-making authority. And let's say, based upon the presentation I've heard you say, that the trial court gives the mother final say-so authority in the areas of education and medical determinations, and gives the father the ones in custodial drop-offs and some other area. Is that, under your logic and your argument, appropriate?
Respectfully, Justice Morgan, I would say the opposite would be appropriate, that father would have medical or at least education, because the one time the child was affected was in the area of education, and that was because of what mother did, mother making the unilateral decision. So a split in authority would mean mother should not have education because that's where she is proven to cause damage in the past disagreements between her and father. So yes, there should be a split in the areas. Recommendation under the factors as found by this court under these findings of fact, both parents should share medical decision making, father should have education and extracurricular, and mother should have religion. That would be under the findings of fact as to who was looking out for the best interests of the children and who could communicate effectively with the other parent. That would be an appropriate split of authority.
So as I'm understanding it, not only is your challenge of what the trial court has done here, it's not merely a matter of the shared authority in terms of one parent having final decision-making authority totally in all areas, but you feel as though as well the trial court would have erred here in not choosing specific areas that you claim either parent may have more strength in than another one, and you have issues with that too.
Correct, Your Honor. We have issues with the fact that father was not provided final decision-making in any area at all. And if the court, under its findings of fact, were to split the authority, that there would be findings of fact that would support a split of authority in father's favor in some areas.
Are you suggesting that an appellate court ought to be making the determination of, assuming that this division of responsibility approach that you've advocated is one that we agree with, are you suggesting that it's a matter of an appellate court deciding what the division of responsibility ought to be or not?
No, Your Honor. Justice Irvin, your responsibility would be to vacate the trial court's order, because the trial court has abrogated all of father's final decision making, and in that sense, that was what was incorrect in the order, and then remand to the trial court with instructions so that the trial court can revisit its findings of fact and make an appropriate division of areas where each parent would have final decision making, if that's what if that's what the court found under its findings of fact, given that this.
So your argument is in essence that the trial court does not have the authority, period, to assign all decision-making responsibility to one parent or the other, that instead, if final decision-making authority is going to be assigned, it has to be assigned some to one and some to the other?
Not under these facts, Your Honor. There may be cases where somebody acts so egregious that they are an unfit parent and they've lost the ability to make decision making. But under where a court has found, as in this case, that both parents are fit decision makers, it's in the best interest of the children for them to share decision making. Joint decision making is some measure of control. So each parent under joint decision-making would need to have some authority at the end of the day to make decisions for the children.
And in that regard, then, should a trial court follow what you're saying you think should be what we would hold here, would you then hold the appellate court then to be able to go beyond the discretion typically accorded to the trial court and say to the trial court that the trial court has erred in choosing areas of final decision making that weren't appropriately assigned to the respective parent?
Yes, Your Honor, because this trial court gave all decision making in all areas to one parent, the trial court committed error in that regard.
Well, I'm accepting arguendo what you're saying in that there should be equal input, but as to allowing there to be some final decision-making authority, there should be categories in which each parent has final decision-making authority, so as to allow each parent to have input, but there is final decision-making authority shared as to different arenas of having the final say-so. You're saying that the appellate court, such as this one, would have the ability to go beyond the discretion typically accorded to trial court, and even within your framework, say that the trial court erred in giving a parent a final decision-making authority realm within a category.
This court could find error under that situation. And in the Hall versus Hall case and the Deal versus Deal case, the court did so find. Specifically in Hall versus Hall, the Court of Appeals said that mother had final decision making except for these certain areas, sports and extracurriculars, because of a tumultuous relationship between the parents, meaning the parents just didn't get along. So the court carved out one exception for mom, and the court said, you committed error because you didn't make specific findings of fact as to why you should deviate from pure legal custody. The court has to make specific findings of fact. So even in a situation where the court has categorized and given final decision making, if they haven't done so without specific findings of fact that show what's in the best interest of the children, there could still be error that this court could find. In this case, however, we have a court that has gone beyond hasn't even made an attempt to give final decision making whatsoever to father. The input is limited to an email exchange and a phone call, and father has no final decision making authority whatsoever.
Counsel, you're well within your rebuttal time.
Okay, thank you, Your Honor. At this time, I will turn the argument over to co-counsel.
Counsel, you have 1 minute and 30 seconds total left of the 30 minutes.
Time, Your Honor. We'll rest on our brief and our and the dissent in the Court of Appeals with respect to the second issue. Thank you.
I'm assuming you want the remaining time for rebuttal. 1 minute and 18 seconds, I think I saw.
Yes, Your Honor.
Okay, thank you. We'll hear from the appellee.
May it please the court. My name is Kip Nelson here on behalf of the appellee, Jessica Halprin. I'm planning to address the joint custody issue, and to the extent the court has questions, Michelle Connell is prepared to address the attorney's fees issue. When a family law court is faced with an acrimonious situation between parents, it has several tools available to it in awarding custody. For example, the court could award one parent sole legal custody and effectively cut out the other parent altogether. Or the court could award joint legal custody and require the parties to return to court every time there's a disagreement over a major decision. Or, as what happened here, the court could award joint legal custody and include a tiebreaker provision that gives one parent or the other final decision-making authority in the event of a disagreement. That decision, as with many matters in family law generally and in custody determinations in particular, that decision should be left to the trial court's discretion. After all, it's the trial court that knows the child the best, that knows the family the best, that knows the circumstances the best, and is in the best position to determine what is in the best interest of the child. The majority below correctly recognized that discretion afforded the trial court and affirmed the trial court's decision. The fundamental problem with the appellant's argument is that joint custody does not mean the same thing as equal custody. For example, parents can have joint physical custody even if there's an unequal division of time. One parent could have the child for 4 days a week and the other for 3. Or one parent could have the child for 5 weekdays and the other parent could have the child for 2 weekend days. In either situation, the parents have joint physical custody despite an unequal division. And that's true even beyond the divorce context. For example, my wife and I have 4 children. We share legal custody of our children. Sometimes there are disagreements, and sometimes one of us may acquiesce in the other's decision. If you knew our family well, you might know which one of us that would be. But even allowing one parent to have the final say in a decision does not strip the other parent of custodial rights. Joint custody is not the same as equal custody. Ms. Wofford has mentioned several times the trial court's findings here that both parents were fit and proper to make decisions for the children. I'd like to address 2 points in that regard. The first is findings regarding fitness go to the award of joint custody in the first place. In other words, if one parent is not fit to make decisions, the court shouldn't be awarding joint custody at all. The court should be awarding sole custody to the other parent. So the fact that parents both have a good relationship with the child and are fit and proper to make decisions, that goes to the question of legal custody in the first place. That's where the presumption that appellant talks about in his brief comes into play, the presumption that biological parents will act in the best interest of their child. But the fact that parents are both fit does not mean that the court cannot award a tie-breaking provision. That was highlighted by the decision last week in McNamara versus McNamara arising out of Connecticut, which was submitted as additional authority, in which that very issue was addressed, where the trial court found that both parents were fit and proper to make decision, and yet one parent was given final decision-making authority. And that was challenged on the appeal, and the appellate court said, the fact that both parents are fit does not strip the trial court of its discretion to award a tiebreaker. Second, the other problem by focusing solely on those findings is that it ignores all of the other findings of fact made by the trial court. Of course, here, the appellant has not challenged any of the findings of fact contained in the order. So they are binding on appeal. In other words, the question is not, was the finding of fact correct? The question is whether the findings of fact support the trial court's discretionary decision. Here, the trial court had several findings that suggested and explained why the trial court thought it was appropriate to award the mother final decision-making authority. For example, the trial court made findings about the state of transition of the family, that these children had been in constant transition for years. They had moved to different locations, that the father had sometimes lived with them, sometimes not, had recently moved to Tennessee, and the constant throughout all of that transition was the mother's presence and the mother's decision-making. That supports a tie-breaking provision. An example, the record is replete with evidence of disagreements between the parties, everything ranging from sports and summer camps to speech therapy to whether the child should attend full day or half day school, and as Ms. Wofford discussed, even which school to attend. And to be sure, the trial court found that both parents were fit and proper, and yet the trial court also made findings about the mother's role in particular. For example, it is Ms. Halprin that is the one tasked with scheduling doctor's appointments in their relationship. It is Ms. Halprin who has more interaction with the school. It was the mother, time and time again, that was involved more. And in fact, the trial court said the children had been in the mother's primary care since October of 2013. All of those facts support the trial court's discretionary decision.
If the trial court is seeing both parents as being very equally situated with regard to what's in the children's best interest in terms of being raised by both parents, then why wasn't it an abuse of discretion to allow the father to have more input than what the trial court allowed?
So, Justice Morgan, that goes to a question of degree. As I understand it, Ms. Wofford has conceded that a trial court can award primary decision-making authority, and then it's a question of how much goes to which person. And that is the quintessential discretionary decision. That is what is left to the trial court to decide. So in this situation, for example, it was not an abuse of discretion to recognize the mother's role in these children's lives since they were born. And as I understood your question, Justice Morgan, the question was why it was not an abuse of discretion to not award the father more. Well, there are no findings in this order that would support primary decision-making going to the father. Could a trial court make those decisions? Sure. If there were different findings of fact made in an order, then a trial court could award decision-making to one parent over the other, to the father in this situation. Or as Ms. Wofford.
Well, in light of the circumstance of the mother having the final decision-making authority and having, in effect, pervasive final decision-making authority in every arena, what would be your response to what the other side has said about the fact that there could just be some perfunctory or cursory communication with the father, with the mother knowing that she's going to have the final decision-making authority just by going by rote through some motions?
So I would disagree with that characterization of the order. A fulsome review of the order shows that the trial court understood exactly what this process would entail. And it's much more than an email and a phone call. I would disagree with that characterization. There are all sorts of orders, decretal sentences in the order about what Ms. Halperin and Mr. Ward have to do. So they have to consult together frequently and in good faith in an effort to agree. They have to make all major decisions in the children's best interest. And the process laid out, of course, it is correct that if one parent has a decision that wants to be discussed, they send an email to the other parent has to respond, and then there's a phone call if there's still a disagreement. But throughout all of that, the parties are ordered to make decisions that are in the child's best interest. Hypothetically speaking, if Ms. Halprin were to disobey that order, she could be subject to contempt. Mr. Ward could bring a contempt motion and say she is violating the order by not acting in good faith, by not making decisions in the child's best interest. Now, of course, that would be a difficult showing to make, but that avenue is there. To say that Mr. Ward has no remedy whatsoever is simply inaccurate. And of course, that provision concludes with the direction that the mother cannot contravene direct provisions of the order itself. It's not as if the mother can change the physical custody arrangements or change anything that's specified in the order. In other words, it's still a judicial order. The tie-breaking provision is simply a pragmatic response to what was already a difficult situation. Again, the court Ms. Wofford brought up the option of a parenting coordinator. In some cases, that might be appropriate. And in some cases, if it's not appropriate to give final decision-making authority to either party, the court can say, come back to court and I'll have to decide. But one of the options available to the court is to award tie-breaking authority to one parent or the other. As I understood Ms. Wofford's argument, she is now asking.
It appears that the court struggled with a couple of things regarding the father's financial integrity. The court made two findings that testimony of the father was not credible, both finding of fact 58 as well as finding of fact 61. Finding of fact 64, the father refuses to seek gainful employment or other contracts for his company. And also it seemed that the court expressed some concern about the father's transition to Tennessee and the fact that he seemed to travel frequently, go on trips with his new wife. Are those appropriate considerations as the court looks at the totality of things to make a decision about the day in, day out lives of children?
Most definitely, Chief Justice Newby. All of these, as cited in the brief, this decision of awarding custody is hard. And it involves the trial court looking at everything before him and her, everything that's affecting the children, everything that's affecting the parent, credibility determinations. Of course, that is the classic purview of the trial court. So although, as Your Honor pointed out, that specific finding was related to financial matters, the trial court said she did not find the father credible. That's not an appellate question to be reweighed on appeal. That is part of the calculus that went into this decision.
Can I also ask you a question about the findings by the trial court? Finding 52 says it is in the best interest of the minor children that the primary custodial parent have final decision-making authority where the parties cannot reach a mutual agreement. Is that a factual finding that is owed deference?
No, Justice Earls. I would say that's at least a mixed question, if not a confusion of law. The best interest determination is not a pure factual finding. However, it is a discretionary question of law. What is, of course, in the child's best interest. But that merely confirms the trial court's rationale. The children lived primarily with the mother. She had more interaction with the school. She was given primary physical custody in the same order. And the trial court said, in that situation, it makes sense for the tiebreaker to be the one who has more interaction with the children. That was not an abuse of discretion. So although I would disagree that it's a pure finding of fact, it certainly supports the trial court's ultimate determination.
Well, and so then the fact that the trial court's rationale was based on which parent has primary custodial, which parent is the primary custodial parent? Because as I understand the appellant's argument, part of the critique of the factual findings by the trial court was that these were findings that related more to custody as opposed to decision making. So physical custody as opposed to legal custody and legal decision making. But if the rationale is based on is it best for the children that the tiebreaker be with a parent who has custody, doesn't it then make those factual findings relevant to this conclusion?
Yes, and I'm sorry if I did not explain that well, but yes, that is exactly right. All of the primary physical custody determinations go into the analysis of the legal custody. It would be strange indeed if one parent were given almost exclusive primary physical custody and the other parent were given final decision-making authority on all decisions. That starts to look a lot like an abuse of discretion if it were flip-flopped. Here, it made sense for the trial court to award primary physical custody, which of course was not challenged on appeal. There was no challenge to the physical custody determinations. It made sense for the trial court to include those findings when, again, deciding on a tiebreaker. It is inaccurate to say that Mr. Ward has no custodial rights for major decisions in the children's life. That's simply not what the order says. He can still exercise legal custody just like any other parent with legal custody. He can open a bank account. He can sign a permission slip. He can take the child to the doctor. All of the normal legal custodial rights that a parent has, Mr. Ward still has those. This tie-breaking provision only comes in the limited circumstance where the parties disagree on a major decision and where they've gone through the process and are still unable to reach a consensus. I think one of the most important findings is in finding 43, where the court said the parties have not been able to co-parent effectively since their separation. This was not a situation where the trial court was creating a hypothetical that at some point in the future, the parents might have a disagreement. This was a hard-fought custody battle. The mother asked for custody, the dad then asked for custody. They fought it out for years. The original complaint was filed back in 2014, and the amended order was entered in May 2019, 4.5 years later. Throughout all that time, the parties were fighting over these things, and the trial court, based on that record, could reasonably assume that disagreements were going to occur in the future. Again, when faced with that situation, the trial court has the option of telling the parties to come back to court, using a parenting coordinator, granting one parent sole legal custody, or providing for a tie-breaking provision, which is what the court did here. The argument that the appellant makes today confirms why this decision should be left to the trial court's discretion. Obviously, we disagree with characterizations of the record that have been made, but that's not what we're here for today. We're not here to decide who was right and who was wrong in deciding which school the kids went to. The question is whether the trial court abused its discretion in its custody determination. The Court of Appeals correctly upheld that discretion and determined that the trial court had appropriately considered the totality of the circumstances and acted accordingly, and we would ask that you affirm. Unless you have any other questions on that issue, I'll turn the time over to Ms. Connell for the attorney's fees issue.
May it please the court, my name is Michelle Connell, and I'll be addressing the trial court's proper award of attorney's fees in this case. 50-13.6 allows a trial court to award attorney fees in its discretion in a custody and child support action to an interested party acting in good faith with insufficient to defray the expenses of the suit. This court has addressed the purpose and the rationale behind this statute in Quick versus Quick, and even before that in Harrell versus Harrell, quoting that case. Allowance for attorney's fees is to put wife on substantially even terms with husband in the litigation. In this case, Mr. Ward filed the complaint for divorce. He is the plaintiff. As a response, Ms. Halprin must have answered and filed counterclaims to preserve those counterclaims. She also included claims for custody and child support. There is no dispute in this action that Ms. Halprin is an interested party. There is no dispute that she's acting in good faith. There is no dispute that the attorney fees are reasonable. The only dispute in this action and in this appeal is, does Ms. Halprin have sufficient means to defray the expenses of the suit? The statutory right to seek attorney's fees is not based on the party's ability to obtain assistance from another, but rather for what are the party's own resources. Does Ms. Halprin have parents that have the ability to assist her? Yes. Is that the basis for this statute? No. It only means that she has parents who are willing to assist with her attorney's fees until the award of attorney's fees is made.
Ms. Cannell, I'm sorry if I could ask you, what does defray mean in that statute?
Well, we have quoted Black's Law Dictionary in that just to cover the expenses for the litigation expenses.
And if a party had won the lottery and won $150,000, would they be able to defray the expenses of the litigation?
Arguably, yes, Your Honor. In that case, that would go to the party's separate estate and a separate account. And in that situation, would the party have, based on their bank account, the amount of money to defray the expense? I think that's legitimate. In this case,
I'm sorry, if a party had found $150,000, would that be included in their estate as a measure of whether or not they could or could not defray the expenses?
I think, Your Honor, if they found the expense and it's legitimately their money and it's placed into an account and that is their separate estate that they can use to pay attorney's fees, I think that is fair to look at the estate. And our law allows us to look at the litigant's estate to determine if there is enough funds to be used for attorney's fees. However,
I'm sorry. So how is a gift of $150,000 different from winning the lottery or finding $150,000 for the purposes of being able to defray expenses?
Your Honor, we believe that in this case, the attorney's fees paid by the mother is not a gift. You are in Judge Murphy's dissenting opinion, he relies on testimony from Ms. Halprin's mother that essentially stating that Ms. Halprin's mother, she testifies that she paid $150,000 in attorney's fees thus far, that there is not a promissory note. And when asked if she's requiring her daughter to pay her back, she said no. And based on that one response requiring, Judge Murphy decides or makes the conclusion that that this is a gift and not a debt. And Your Honor, we would disagree with the ability of the appellate court to become a fact finder in this case. There's no case law to support that payment of attorney's fees is a gift or is an asset of the litigant who's receiving the attorney's fees. The appellant has not cited any cases in North Carolina or in the nation that would support that payment of attorney's fees is a debt or automatically becomes a part of the litigant's estate. And so we would offer, Your Honor, that it would be error to require that calling prepayment or payment of these attorney's fees, which Ms. Halprin never received. They went straight to the attorney as her separate property or her estate to be considered by the court in defraying the cost of the expense.
Thank
you. I interpreted the argument made by your colleagues with respect to this point to say, in effect, that the mother had a continued right to the ability to expect that her parents would continue to make payments. Is that your reading of their argument, or do you have a different one?
I did not interpret it that way, Justice Irvin, but that does not mean that's actually correct. But I do need to address that.
How did you interpret it? I mean, these are monies that have already been paid, correct?
Correct. And to the extent that mother needs to pay that or will pay that back over time, that's one issue. But the other issue, Your Honor, goes to the fact that should her parents be saddled with having to pay for a litigant's case where the parents are not the party, where the parents have not, are basically assisting their daughter until such time that attorney's fees are filed or are ordered. And Your Honor, if I may, to go to sort of the public policy of this, in this case, it makes the findings of fact make fairly clear that Ms. Halprin cannot afford to pay the attorney's fees. And I'm referencing the cash flow issues that she makes about $3,000 a month. She's living with her parents with the minor children. Her children are her parents are assisting. And that's contrary to Mr. Ward, who is living with the woman that he left the marriage and living with her, and she is paying for all his expenses. So there's Ms. Halprin who cannot pay for attorney's fees. Who should bear the burden for that? Should it be her parents, who are not parties, who are simply being good Samaritans, and they shouldn't be punished for using their retirement or their life savings to assist in this lawsuit that Mr. Ward started? Or should it be Mr. Ward who bears the burden? And it was Mr. Ward who filed the lawsuit. He's the one who left his family for another woman. He's the one who doesn't work for fear of his earnings being obtained by creditors. He is, according to the findings of fact, 58, a kept man essentially, because he is paid by his paramour, now wife, to provide services such as getting coffee and water for Miss Irvin and getting gas or washing his car. That's where the burden should fall on when a litigant does not have the ability to pay. And Your Honor, I would like to point out too, he didn't pay child support. He's about $59,000 in arrears. And the statute specifically, 50-13.6 specifically talks about when a party doesn't pay adequate child support, then the other party is entitled to child support. So in this case, Your Honor, to allow, and I think it'd be fair to apply it to a lot of cases, to allow a precedent where Ms. Halprin and her parents are being penalized because her parents are floating her the money to try to, as Mr. Nelson said, 4.5 years of litigation because she can't support herself and Mr. Ward's not supporting the children. To allow, to penalize them and have not awarding attorney's fees would it gut the intention of the statute. It gut the intention to equalize the playing field. And in this case, it would reward a bad actor. And that's what the statute's for, is to protect the litigant who doesn't have the parent that may be able to give them money, but who needs the money back for later retirement. Your Honor, we are asking that this court affirm the majority opinion in this case and therefore affirm the trial court's order. And unless there's any more questions for me or for Mr. Nelson, we would respectfully rest.
Thank you, counsel. We'll hear from the appellant with rebuttal.
May it please the court. Mr. Chief Justice, Associate Justices, I'm Hunt Walford, and I'd like to address the second issue that Ms. Connell spoke about briefly. We agree that this issue comes down to the argument over what sufficient means in the statute. And unlike appellee would have the court find, the statute does not limit means to money from income. It doesn't limit means to money in the bank at the time the lawsuit is filed, nor indeed does it limit or does it exclude a gift that one may receive during the lawsuit. So means simply means money. And as the dissent in the Court of Appeals found, in this case, there's sufficient evidence in the record for the trial court to have found that mother had sufficient means to satisfy the attorney's fee claim in this case or to pay her attorneys. The problem and our contention is that at a minimum, there needs to be a more complete examination of the estate of the party seeking attorney's fees than was done in this case to determine whether that sufficient needs analysis is met, and that wasn't done here. So we're asking this court to reverse the Court of Appeals and vacate the trial court's ruling.
Thank you, counsel. Thank you, everybody. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is in recess for 45 minutes. God save the state and this honorable court.